American Jewellery Company and others versus Commercial Corporation Jamaica Limited and others.
Lord Wilson will give the judgment to the board.
This appeal comes from the Court of Appeal in Jamaica and relates to a contract made in August 1999 for the sale of 2 adjoining shop premises in the St. Andrew area of Kingston. The vendor was American Jewellery Company Limited, but it will be clearer if I refer to its owner, Mr. Kemlani. The purchaser was Commercial Corporation Jamaica Limited, but it will be clearer if I refer to its owner, Mr. Tawani. The contract price was $20 million, and of course I refer to Jamaican dollars. At the time of the contract, Mr. Kemlani was occupying one of the shops. One of its terms was that Mr. Tawani would lease it back to him at a monthly rent of $125,000. Mr. Kemlani instructed an attorney, Mr. Clough, to act for him in the sale. Mr. Tawani instructed another attorney, Mrs. Masado, to act for him. Under the contract, completion was fixed to take place in September 1999. But for various reasons for which Mr. Kemlani was largely responsible, there was an extensive delay. Mr. Tawani made substantial interim payments towards the price. Ultimately, in June 2000, he secured transfer of the ownership of the shops, subject, of course, to Mr. Kemlani's continued occupation of one of them. So Mr. Clough and Mrs. Masado turned their attention to the balance of the price payable by Mr. Tawani. Mrs. Masado contended that completion should have taken place at the latest by February 2000, that Mr. Kemlani's payment of rent should therefore have started no later than March 2000, and that there should therefore be a deduction of $575,000 in the balance owing by Mr. Tawani. She contended that there should be a further deduction of $863,000 by way of an advance of the rent payable by Mr. Kemlani up to December 2000. In July 2000, she sent Mr. Clough a check for $2 million on account of the balance payable, but she expressed it to be conditional on his acceptance of those 2 deductions. Mr. Clough cashed the check. In August 2000, Mrs. Masado sent Mr. Clough a further check for $388,000, which she said was the balance of the price payable. She had furnished him with calculations which made allowance for the 2 deductions. She asked Mr. Clough to sign and return to her a copy of her letter by which he would acknowledge that the payment was in discharge of Mr. Tawani's obligations under the contract. Mr. Clough did so. In these proceedings, Mr. Kemlani contends that he never gave Mr. Clough authority to accept the 2 deductions from the price payable to him. The Court of Appeal substantially rejected his contention, and so he appeals to the board. Although the evidence in this respect is unsatisfactory, the board assumes that Mr. Kemlani never actually authorized Mr. Clough to accept the deductions. So the question is whether Mr. Kemlani invested him with apparent or ostensible authority to do so. More specifically, was Mr. Clough's acceptance of the deductions within the scope of the authority which Mr. Kemlani had conferred on him when instructing him to act on his behalf in the sale? The answer of the board is yes. A solicitor instructed to act in a sale would usually have authority of that width. And Mr. Clough had earlier agreed to other substantial variations of the terms of the contract without any outward sign of express authority on the part of Mr. Kemlani. So the board will humbly advise Her Majesty to dismiss Mr. Kemlani's appeal.